Police break into a home without a warrant. Inside, they find real, undeniable evidence of a crime. And then something strange happens. Because of how they found it, that evidence is thrown out of court, and the person walks free. It sounds like a loophole, a technicality, the kind of thing that makes people furious at the justice system. But that technicality is actually one of the most important rules protecting every home in America. And it comes from a single case in 1961 that began with police looking for a man who wasn't even there. This is the story of Mapp versus Ohio, the case that took a promise buried in the Fourth Amendment and finally gave it teeth against your local police. It is the reason an illegal search can sink an entire prosecution. One note before we begin: this is legal history and education, not legal advice. To understand it, we go to Cleveland, Ohio in May of 1957. The police are investigating a bombing. A tip comes in. A suspect wanted for questioning is supposedly hiding out in a house on the top floor of a two-family home. That home belonged to a woman named Dollree Mapp. 3 officers arrived at her door and demanded to be let in. But Dollree Mapp did something most people don't. She called her lawyer, and then she refused to open the door, telling the officers to come back when they had a search warrant. She knew, at least in outline, that she had a right to say no. So the police waited outside and watched the house. About 3 hours later, they came back, now with more officers, 7 or more in all. When Mapp didn't come to the door fast enough, they forced one of the doors open and let themselves in. By the time she reached the hallway, the police were already inside her home. She demanded to see the warrant. An officer held up a piece of paper and claimed it was one. Mapp grabbed it and tucked it into her dress. A struggle followed. The officers wrestled the paper back and handcuffed her for being, in their word, belligerent. Meanwhile, her lawyer had arrived outside, and the police would not let him into the house or let him see her. Then they searched, everywhere, through her dressers, a suitcase by her bed, and down into the basement. They never found the bombing suspect. He simply wasn't there. But in the course of tearing through the house, in a trunk, they turned up some materials that were illegal to own under Ohio law at the time. And so the search that started over a bombing ended with a completely different charge. Dollree Mapp was arrested and convicted, not for anything to do with the bombing, but for possessing those illegal materials, which she said had been left behind by a former boarder. Her conviction rested almost entirely on what the police had carried out of her home that day. But look at how they got it. At her trial, the prosecution never produced a search warrant. None. The Ohio Supreme Court itself would later admit there was considerable doubt that any valid warrant had ever existed. By any honest measure, the police had entered and searched her home illegally. And here is the part that stuns people today. Under the law at the time, it didn't matter. In an Ohio court, evidence seized in an illegal search could still be used to convict you. The police could break the rules getting it, and the state could still hand it to a jury. How could that be? The answer went back to a 1961 crossroads built on an earlier case, Wolf versus Colorado from 1949. In Wolf, the Supreme Court had said something half-finished. Yes, it ruled, the Fourth Amendment's protection against unreasonable searches does apply to the states, but the remedy, actually throwing the illegal evidence out, was not required of them. States could choose whether to enforce the right at all. Think about what that left behind. A right on paper with no teeth. You had a constitutional protection against illegal searches, but if the police violated it, nothing happened to the evidence. It could still be used to put you in prison. It was a lock on the door with no key, a guarantee the government could simply ignore whenever it chose. Dollree Mapp appealed her conviction all the way to the Supreme Court. Interestingly, her lawyers spent much of their energy on a free speech argument about the materials themselves, but the justices fixed on something far larger than one woman's case: the lawless search that had started it all, and the empty promise the Fourth Amendment had become in state courts. Because the real question was this: when the police seize evidence through an illegal search, should a court be allowed to use it? Or must that evidence be thrown out, excluded, no matter how damning it is? There is a name for that idea. Lawyers call it the exclusionary rule. It wasn't a new invention. All the way back in 1914, the court had ruled that in federal cases, evidence from an illegal search couldn't be used. The government shouldn't profit from breaking its own law. The unfinished question, nearly 50 years later, was whether that same rule bound the states, the local police who handle the overwhelming majority of criminal cases in this country. In 1961, the court gave its answer. By a vote of 6-3, it said yes. Writing for the majority, Justice Tom Clark declared that all evidence obtained by searches and seizures in violation of the Constitution is inadmissible in a state court too. The earlier decision, Wolf, was overruled. From that day forward, the exclusionary rule applied to every police force in America. And the reasoning cut to the bone. A right without a remedy, the court said, is no right at all. If police can violate the Fourth Amendment and courts can still use whatever they seize, then the protection against unreasonable searches becomes, in the court's memorable phrase, a form of words, valueless and empty. To grant the right but withhold the remedy is to grant nothing. But notice what the rule is really for. It is not designed to reward criminals. Its purpose, the court explained, is to deter, to remove any incentive for the police to break the law in the first place. And there is a second purpose, just as important, to keep the courts themselves clean. A court that knowingly convicts you with illegally seized evidence becomes a partner in the very lawlessness it's supposed to judge. Justice Clark put the hard trade-off in one unforgettable line. Sometimes, yes, this rule means a guilty person goes free. The criminal goes free if he must, he wrote, but it is the law that sets him free. Nothing can destroy a government more quickly than its failure to observe its own laws. The point was blunt. When the state cheats to win, the state loses something worth more than the case. 3 justices strongly disagreed, and their argument deserves a fair hearing. Justice John Marshall Harlan warned that the court was overstepping. The Constitution forbids unreasonable searches, yes, but it does not dictate that every state must use this one specific remedy. States, he argued, should be free to discipline bad policing their own way, and the court was forcing a single rigid rule on all of them from the top down. And there was a real painful cost he refused to ignore. Sometimes obviously guilty people would walk free, but the majority held, and the effect was immediate and nationwide. After Mapp, an illegal search was no longer a free move for the police. Break the Fourth Amendment, and the evidence you find could vanish before it ever reached a jury, whether you were a federal agent or a small-town cop. And Mapp was only the beginning. It fired the opening shot of what's now called the Warren Court's criminal procedure revolution. A stretch of the 1960s when the Supreme Court took the promises in the Bill of Rights and one by one forced the states to honor them. The lawyer the state must give you in Gideon. The warning police must read you in Miranda. The privacy the government must respect in Katz. Mapp is the case that opened that door. Of course, the rule did not stay as sweeping as it began. In the decades that followed, later courts carved out exceptions, moments where illegally obtained evidence could still be used, like when police act in good faith on a warrant that later turns out to be flawed. The exclusionary rule today is narrower than it was in 1961, but its core survives. The government still cannot freely profit from an unconstitutional search, and that makes Mapp one of the most quietly consequential rules in your daily life. Every time a court throws out evidence from a bad search, every time a defense lawyer files a motion to suppress, every argument over whether the police really had a valid warrant, that is Mapp at work. It is a large part of why the warrant requirement on your front door means anything at all. So step back and look at the pattern. We've watched the Constitution show up in a police station, in Miranda, in a prison cell, in Gideon, in a phone booth, in Katz, in a school hallway, in Tinker, in a fight over the court's own power, in Marbury. And a great deal of that began right here, at the front door of a home in Cleveland, with an officer waving a piece of paper that may never have existed. The same quiet idea binds them all. A right the government is free to ignore was never really a right. So the next time you hear that someone got off on a technicality, remember what that technicality actually is. It is the rule that the government has to obey its own law in order to use what it finds against you. The Supreme Court decided, in the case of an illegal search and a warrant that likely never existed, that the ends do not justify the means, not even for the police, not even to catch the guilty. If that's the kind of thing you want to understand more deeply, consider subscribing. We take one landmark case at a time, and we try to get it right. Thank you for watching, and remember, this video is for education in history. It is not legal advice.